Yep. Okay. Go!
Will you hand me my screen box?
Now go.
We're on the record in Hector Van McGregor versus Julie Hope. Case number is Butler County 24 LM 1193. Mr. McGregor appears in person and by and through his counsel, Kurt Holmes. I believe Ms. Hope appears as grateful legal advocate. This matter is before the court, with the court having stayed the earlier writ in the case and having set the matter for a hearing here and now, as was requested by Ms. Hope. Depending on the nature of how the parties are wishing to go forward, I might take up the other trial first or try to ascertain what people are indeed wishing to do. Ms. Hope raises several issues, but the one that I was the most keen to try to understand today at this point is there was a document submitted alleging that the plaintiff in the case might have a different perspective or a different way forward. And I guess I might defer to you, Mr. Holmes, to advise the court as to any opinion you may have about that document or what you would like to do at this point.
Your Honor, I would have to defer to Mr. McGregor as to what he wants to do today. I'd have to ask him in front of the court.
All right. Mr. McGregor, I do have the document that was alleged to have been written and signed by you on the 18th of this month. What indeed are you wishing to do at this time, sir?
I wanted the eviction to happen. And this document that I signed was post eviction to help Miss Hope get the eviction notices off her record. And she submitted that. And in that process, that is my wish, is to have the eviction served.
Okay. Ms. Hope, with respect to the question of the eviction proper, was there anything you wanted to say about this document that has been submitted?
Good afternoon, Judge Murfin. Thank you for your time, sir, and thank you for Butler County District Court's time. And thank you to the state of Kansas. I am very appreciative for this opportunity. My first question, sir, are we on record on for this case?
Yes.
So this is all available this is all being transcribed, sir?
It's being recorded by the Zoom hearing that we're all on. So it would be possible to access the audio and visual from the Zoom hearing.
So it will be submitted in conjunction with today's hearing. Is that correct, sir?
Well, I'm not sure what you mean by submitted, but it's being recorded and it would be available. Yes, ma'am.
It will be transcribed with the hearing
It will
case.
probably not be transcribed absent some sort of an order concerning transcription, but it is being recorded.
Well, I want to be sure that I stayed on the record twice. Then the defendant, Ms. Hope, and I speak in the term the defendant as this allows me to better communicate to you more effectively, sir. The defendant is still under the doctor's orders that her mental capacity is still not rendered fully capable. And I've submitted that documentation, and I've noticed that there hasn't been any, I honestly don't know what that means or if it has any bearing in this case. And I don't really understand what's going on today, but I am grateful for this opportunity to participate. And I will do the best that I can, since I don't have counsel at this moment, which I'm working on the process of securing. But in terms of your question, sir, will you please repeat it respectfully?
I just wondered, with respect to the document you had submitted from Mr. McGregor, what opinion you had with respect to that document.
Well, can you be more specific in what you're asking me in that question? Because that's a very broad question, sir.
Well, what do you think it stands for, and what do you think the court should do with the document itself?
Well, Your Honor, the defendant submitted this document as evidence because Mr. McGregor stated that this document could be used to appeal and I apologize, I'm having anxiety, to appeal and any of these writ of restitutions in whatever that document says. So my understanding was that that was the case. And also in a follow-up conversation, Mr. McGregor stated, the defendant asked the plaintiff, why did you sign this written statement? And he stated that it was because he thought that it would not be filed in time for the court to hear it.
Okay.
And so my understanding with that, it was in his belief that his conduct, like many other points in the briefing submitted by the defendant today, to include the previous motion submitted on the 18th, was just another instance of the plaintiff believing that his actions were above the law in this case for some reason. So
Okay.
he and I both, he was the person who even stated that he wanted to dismiss these cases. My understanding, and the defendant has some safety concerns in speaking out about these matters because of the many injuries that have occurred as a result of these claims, in an attempt to cause defamation of character to the defendant's personal, professional, and legal records for the case, and just for her livelihood, her financial livelihood, and merely an attempt to allow access to the plaintiff to have easy access to exploit the defendant sexually whenever he sees fit. This can also be proved in a voice memo that was recorded this weekend, where the plaintiff states explicitly that he in fact likes the idea of having the defendant here for him to be able to come to and receive sexual benefits from these ongoing matters.
Okay. Mr.
And Ms. Hope requests also that this case be continued when she has an attorney present to represent her in this case, as this is a very complex and it involves appeals of 3 evictions, and it's merely an attempt for the plaintiff to elude and not be responsible for financial litigation, as these 2 individuals have had an ongoing relationship, sexual relationship, sometimes consensual, other times not consensual, other times exploitive, over the past years, where the defendant has resided here for over at least 12 months in full over the 3 months. Respectfully, the defendant seizes his There's more to say, but the defendant is having trouble with some anxiety.
Okay. Mr. Holmes, anything you'd like to say on the subject of the submitted letter?
No.
Okay.
Mr. Holmes, or excuse me, Your Honor, Mr. McGregor, the plaintiff, also throughout the course of this week has been telling the defendant that he wants to dismiss these cases, that he just wants the defendant to be reasonable, and that he will give her his vehicle in restitution for the vehicle damage and relocation, financial 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 uh financial amount to relocate the defendant, and he's defined the specific terms, the length, and the amount, and he stated these facts and continued to state these facts up until Sunday at 8 p.m. And so the plaintiff requested that if an agreement was made in dismissing this case and this hearing not be held, that Ms. Hope, the plaintiff, would request that any agreements be written so she could have an attorney review the agreement and the soundness of it. And the plaintiff misled the defendant to think that this case would be conducted in a settlement agreement. And as such, the defendant has not had much time to be aware of what's really going on in this case, as much similar to most of these other cases, Your Honor. So I do beg and pray for the court to allow the defendant, Ms. Hope, to seek legal counsel in how to move forward in the most reasonable way as described by the plaintiff, Mr. McGregor, and in a setting where she is in time frame where she's able to purchase a new vehicle if need be, to relocate long distance and finish up her medical appointments, to receive and enter the mental health long-term treatment as is planned by her therapist, her PCP, and her psychiatrist, and referrals to medical rehabilitation treatment for neurological injuries, Your Honor, sir.
All right. Thank you. I'm going to go off the record just for a moment. I'll reconvene here, hopefully in just a few minutes.
Your Honor, before you go, I respectfully ask you to inform me, as a person who's being forced to represent themselves via pro se under these conditions, what is this court hearing title, and what is the time length of this? Is this a trial? Is this a pre-trial? What is going on?
This is with respect to your motion and my wanting to at least hear on the issue of the submitted letter. And I'm going to look at the file for a moment, and I'll come back in probably 3 to 5 minutes. Okay?
Your Honor, yes, sir. And then what time frame is allotted for this? Is this a pre-trial or a trial, Your Honor, sir?
It's actually a hearing on your motion, the motion that you filed on the 18th of October. For motion to stay the writ of restitution, Your Honor? I had stayed the writ pending today's hearing date, and I want to consider first the question of this letter, and then from there we can go forward depending on the nature of the court's ruling.
Yes, Your Honor, I would like to relocate as soon as possible, please, Your Honor. So I pray that we can reset this soon, and that we can work together to come to an agreement where both parties have legal representation as this process, all of this is causing undue mental distress, and I just want to move him on with my life, sir.
All right.
Please.
Thank you, ma'am. And I'll be back momentarily.
Thank you, Your Honor.
All right, we're back on the record rather in the McGregor versus Hope 24 LM 1193 case. I think that from my perspective, this may well be one of the more challenging cases I've heard. It's challenging to the extent that Ms. Hope has long had some good and reasonable explanations for the requests that she has made of the court. The court had sought to hear what she was saying and to hearken to her heart's cry where that seemed appropriate to the court. I think for his part, Mr. Holmes has done an excellent job for his client and in point of fact, arrived at the destination that had been sought in terms of the orders the court had earlier made in the case. I do think that the letter from the 18th of this month, a week ago, is indeed, as Ms. Hope has explained, somewhat complex in that it has unequivocal language with respect to Mr. McGregor's willingness to not only with the case before the court at this time, but with respect to some other cases, take whatever action might be necessary to vouchsafe to Ms. Hope basically a change in what I'm understanding to be the current state of the record. I do think that that level of complexity does augur for honoring Ms. Hope's request for continuance. I am going to continue to stay the writ, the service of the writ. I'm going to set this over 2 weeks to give Ms. Hope a chance to retain counsel, which she says she wishes to do. I think our next court date, or 2 weeks from now, I believe, is December 9. Ms. Baylin, how many cases are already set at 3:30 that day?
I have one set at 3:30.
Okay. Well, I'll set this one also at 3:30 and we'll take it up as soon as that earlier case is done. I do think it is important if there are additional documents that either side wants the court to consider that they be submitted by next Monday, the 30th of November, to the extent that those are available. I also understand that some documents might not be available by that date, but I would ask that they be submitted as soon as is possible thereafter. It looks like, sorry, I had said November 30th, I meant by December 2nd. And I do think it's important that we get to a finish line. Ms. Hope, you're requesting a continuance. I'm granting that continuance, but I would like to try to get this case finished up for your benefit, for Mr. McGregor's benefit. It has been now a fairly protracted matter, but I am going to give you a chance to do as you have requested here today, and I'm hoping that we can be at a finish line with respect to this case by the time we take evidence or have an agreement announced on December the 9th.
Your Honor,
Yes, ma'am.
I apologize, but may I speak before you close, sir?
Well, I'm happy to have you do that, but
Yes,
if
sir.
you're intending to hire counsel to assist you with this, it may be the case that you would benefit from having counsel's advice as you go forward with the case.
Your Honor, I just have two simple questions. Your Honor, I request the attorneys that I have conferred with, they have said that their availability, if you were to continue this case, would be no sooner than December 16th. And so in finishing up final agreements and hiring and choosing two, among two of the choices, I would request that in making a final decision that you set this case over to the 16th, also to allow each party to submit evidence that will involve, uh, uh, also to allow time to, file subpoenas for police officers of Andover Police Department, who have been, who've been present when statements of appeals were said to be, an agreement from by Mr. McGregor, and also in regards to allowing the defendant time to be able to, uh, get everything resolved, with her vehicle so she can actually drive and participate in the requirements of doing all the filing of this paperwork, especially since the defendant is not being granted access to her USPS mail and has to travel 30 minutes to the Butler County District Court. And so this requires a working vehicle. And as such, the filings do state that there is record that Mr. McGregor, the plaintiff, has admitted to the defamation, the destruction and the vandalism and accessing and with of this vehicle, which, by the way, is only legally allowed to move with a mechanical device, regulated by the federal government. And so Mr. McGregor has violated those federal laws as well. And also so to allow Miss Hope to be brave and be able to continue to receive therapy and psychological services to move and relocate and be able to participate in the hearing for the 9th, Your Honor. I request that you grant the additional week, as this does involve 2 additional appeals of the matter, and there could be implications to what happens in those other 2 cases, as this is a very complex case. And so I do ask you you reconsider the date, please. And I also ask for guidance on if the parties decide to expedite this prior for some crazy reason, so the defendant doesn't have to go through the undue distress of all of this. What does a defendant do when the plaintiff's attorney doesn't provide documentation of any settled agreements in the past that have been noted in these legal briefs regarding the case? And I also request that the judge order that the plaintiff's attorney submit the legal documentation in writing, so Miss Hope, the defendant, can have this legal documentation in speaking with legal representation in pursuing the next steps that you are adhering to your oath of legal conduct, which you have my deepest admiration and respect and appreciation for, Honorable Judge Pro Tem. Thank you so much. I ask that the defendant be able to understand what the plaintiff had wrote in that legal documentation and be able to provide it to legal counsel as well. Please, Your Honor.
Mr. Holmes, anything you'd like to say?
Yes, Your Honor. I don't know what we're doing. I've already got a judgment, and I don't have any intent of giving any more evidence or documents or anything. So I have no idea what she's talking about or what we're doing. And so as far as I'm concerned, unless the judgment's been set aside, we already have a judgment. You're staying this on the writ for us to come back and talk about having her removed from the home that we've been trying to get since August 13th. So I
Your
don't,
Honor,
I
I
would,
asked,
I would certainly object to any further continuance.
Your
Okay.
Honor, I object to the plaintiff not providing
Well,
not providing communication of what he wrote in that document. The document's
well,
illegible. I don't understand it, Your Honor.
I think,
I don't know what it says.
I believe the order is filed in the case, and I don't know for certain what other document you would be speaking of. I do, and I am going to hearken to your request to continue the case, but my thinking is 2 weeks, I would like to think is enough time for you to get counsel hired if that's indeed what you're going to do. And I would like to think that that would also give you adequate time to prepare any further argument that you have in the case. I acknowledge that the letter does create some potential complexity, and I understand your desire to want to retain counsel. But beyond that, we can take up any further argument on your motion. But I think that Mr. Holmes is right in terms of desiring to get this to a finish line. And at this point, I'm doing exactly what you requested. I'm continuing the case to give you a chance to get counsel. We'll take up any further argument you may have on the motion at the next hearing on December 9th, and then hopefully we can come through to a conclusion at that time. And I'll just look forward to seeing each and all December 9 at 3:30.
Your Honor, if I may object, the defendant does not know what the plaintiff's attorney submitted, the writing based on the judgment, based on the order that was signed. So how is the defendant able to confer with counsel about this judgment if the judgment was submitted with transcribed writing by the plaintiff's attorney, Kurt Holmes of Wichita, Kansas, and he will not type it for the defendant.
Well, the
to
order,
read.
the order and the writ were typed and submitted by Mr. Holmes.
I
And
I never received that, Your Honor, sir.
Well, it's in the court file, and if you want to, if you're coming to El Dorado, as you indicated, you may be anyway, you're welcome to request a copy from the clerk. For that matter, I don't know. I would have thought that perhaps that document had already been sent to you. Miss Baylin, do you know if the journal entry was sent to Miss Hope?
I don't remember off the top of my head, but I would assume so.
Okay. Well, if you would please just send her another copy as a courtesy.
Yes.
And Ms. Hope, you can take up any of the concerns you have with counsel whom you've indicated you've already spoken to, and they should be able to help you from there.
Yes, Your Honor. And if I may, I would also like to request to dismiss this eviction as well, seeing as Mr. McGregor has agreed to release any claims associated with this action as said in this agreement. And the defendant requests this because in the motion made today and in the brief and also submitted on the 18th, it did state multiple motions to modify, stay, or dismiss for lack of prosecutorial for possible.
I don't think it's said for lack of prosecution. I had reviewed that recently, but if you want to renew any motions along those lines when we reconvene, you're welcome to do that. I guess my thinking is you had begun today's hearing saying that you hope to hire counsel to take up all of the matters that letter may be touching on. Is that what you want to do?
Your Honor, I respectfully am not well versed on the law. However, I believe this case is founded. It lacks jurisdictional jurisdiction because the case was this is a
Well, that
okay. I'm sorry, Your Honor. I'm so sorry. I don't want to get into much detail. I'm just stating this request as it was a motion, so I'm making another appeal, Your Honor. I understand. I don't understand the complexity of it, but if you feel there's a legal basis cited in the case law and the court and the Kansas annotated case references in these case briefings with the evidence, I would request that you also include that in your decision and whether to either dismiss this case and or if you don't see fit and if you see that it is has legal standing to dismiss, I ask that you do that. But I also request that if you don't find legal standing, then to continue it for the reasons listed in the briefs filed with the courts. And I also request that all these documents be filed in the court legal records that are available for public viewing as well, please, Your Honor, to include specifically the written agreement, as none of that nor the journal entry have been filed on the Kansas judicial website, Your Honor. Do you believe there's judicial cause to dismiss this case, Your Honor, sir?
Well,
With
the
the current
question,
evidence?
what you had asked me initially was to continue the case because of the complexity that was engendered by the November 18 letter. I had granted that request. Is that not what you're wanting me to do?
I'm asking you to do, if you can do both. I don't know if I'm legally able to do that, Your Honor, so I apologize. I'm pro se and I don't know. I don't know. So I'm asking you if there's legal basis to dismiss the case.
Well, in as much as you had initially sought to have an opportunity to hire counsel, I feel like I want to give you that opportunity. And if when we reconvene on the 9th, either through counsel or if you're still representing yourself, you have anything else you'd like to discuss on the motion or any other request you may wish to make of the court at that time, you're welcome to do that.
Your Honor, yes, sir. And my question is then in regards to this legal case, and again, thank you so much. I feel so grateful and honored for this opportunity, Your Honor, Butler County, Kansas. And I'm so grateful the Air Force and the University of KU and Avila University and my medical providers and family and friends have given, and God have given me the strength to advocate for women's rights in a civil suit or any other possible criminal lawsuits that may proceed. I'm so thankful for the honor to be brave and the encourage of Representative Vic Miller to be brave in advocating for justice as a woman with the honor of having a degree of a bachelor's of social work who has an oath to advocate for legal rights. I'm so grateful, and I appreciate you allowing me to state that. I just wanted to apologize that I don't understand this process. So going forward, in order to receive documentation of what's going on exactly in these court cases, and this is my only way to access these court documents that I've been ordered to come to the Butler County courthouse because I'm not being permitted access to my USPS mailings, Your Honor. Is that the correct way? And what does the defendant do if the plaintiff attorney refuses to communicate with the defendant to receive this documentation or any? And
well, as we had discussed, I don't know what, if any, additional documentation would be anything that Mr. Holmes would even have access to, let alone be in a position to have to make available to you. I don't know specifically what you may be speaking of, but I do know this much. I think that you filed a motion on the 18th seeking a stay and an opportunity to be heard today. I had hearkened to your heart's cry, initially at least, on the strength of the submitted letter and to try to ascertain what the meaning of that letter was from both yours and Mr. Holmes' client's point of view. You had sought an opportunity to hire counsel to assist you, given what you've explained is the complexity, and I understand where you're coming from there. And I have granted your continuance request to December 9th, and we will go from there. And certainly, if you do indeed hire counsel, I would suggest that that person will probably be able to assist you as well.
Your Honor, but to get the written orders that come as a result from today's court hearing and November 8th court hearing, and it's the only way for the defendant to come to the court is to the Butler courthouse.
The only document that will be coming out of today's court hearing is just a notice of the new court date that I've just given you, December 9th. I don't suspect there'll be any other written document coming out of today's court hearing.
Will these documents be submitted to the court case on the judicial court case record for public viewing as all the other documents have been submitted, Your Honor? Will I be allowed the same legal right to have those be timely submitted on this court filing?
You'll be sent a copy of the document that will have the new court date on it, and any other document that's filed in the normal course of business should be accessible electronically.
But the filings I filed with the court have been submitted for the motions to postpone the court to continue the case. Is there going to be additional documentation posted on the court?
If you submit additional documentation, I suppose so. Mr. Holmes already indicated he doesn't believe there's any other submission necessary by his client, Mr. McGregor. But Ms. Hope,
I'm so sorry, Your Honor.
No apology necessary, but I've sought to answer your questions, and I do understand that you had begun by asking for continuance. I've granted that request, and I'll just look forward to seeing you and Mr. Holmes and Mr. McGregor on December 9th.
Your Honor, do you believe that this case should be heard before a different judge as this case is?
You had raised that specter before, and I had ruled on that specter before. I never ascertained from you that there was any reason other than you didn't feel comfortable, but I never knew what it was specifically. And as the record would otherwise reflect, in prior hearings, you have at once told me that I was doing a good job, and then told me that you might prefer to have another judge assigned to the case.
In lieu of new evidence,
I think
filings to the case
well,
stating there's 3 lawsuits. Your Honor, I respect.
Let me stop you for 1 second.
My apologies.
If you have anything else that you want to add by way of further motioning the court, you're welcome to do that. But I would encourage you, please, to get that in before the 2nd so that Mr. Holmes could have a chance to look at that as well. But those will be the orders of the court.
Okay. Yes, Your Honor.
Look forward to seeing you guys.
Yes, Your Honor.
Thank you.
Thank you. God bless you guys. Thank you.
And
Thank you all. Thank you so much. Miss Wells, thank you so much for your help. I hope I'm doing this process correctly. I sent you an email. Can I call you later tomorrow, ma'am, if I have questions?
Julie, if you have questions, you're welcome to phone me, yes.
Thank you for your professional integrity and communication. Thank you all. Bye-bye.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today?
Okay. This is a joke. This is a joke. Today is an absolute joke. We need an interpreter. I need an interpreter when I cannot express myself sometimes. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
Come and go.
I have no taste for that. And trust me, after today, I'm sitting up here, I'm the one that needs a drink.